Prohibition fuels organized crime. Gangsters show up in newspapers with Thompson submachine guns and sawed-off shotguns. High-profile massacres shock the country. Suddenly, it's not just a farmer's rifle or a soldier's musket. It's rapid-fire weapons in urban streets. In 1934, Congress passes the National Firearms Act. It doesn't ban these weapons outright, but it taxes and regulates them heavily. A few years later, in 1939, a case called United States v. Miller reaches the Supreme Court. The question: can the federal government regulate a sawed-off shotgun under the National Firearms Act without violating the Second Amendment? The court says yes. In doing so, it focuses on whether this particular weapon has a reasonable relationship to a well-regulated militia. It never comes out and says, the Second Amendment protects only a collective right. But it definitely doesn't announce a broad individual right to own any weapon, for any reason either. For many decades, legal textbooks and lower courts read Miller as supporting a militia-centered understanding of the Second Amendment. Gun laws, especially at the state and local levels, continue to expand with relatively little constitutional pushback. In 1968, after the assassinations of John F. Kennedy, Martin Luther King Jr., and Robert Kennedy, Congress passes the Gun Control Act. It restricts mail-order sales and bars certain categories of people, like felons, from buying firearms. The law is controversial, but the Second Amendment is still not the central battlefield. The big fights are political, not constitutional. So when does that change? When does the Second Amendment become the rallying cry? To answer that, we have to leave the courts for a minute and talk about something else: marketing. To learn about the history of the Second Amendment, check out the full documentary in the description below.